Ladies and gentlemen, and welcome to this session on democracy and equality, the Constitution story. Just 40 days ago, we celebrated our 76th Republic Day, the day that marks the Constitution coming into effect. We are not only the largest democracy in the world, but we are also armed with the longest Constitution in the world. Yet, our Constitution has been chiseled and hammered at least 106 times just in 77 years. We are still grappling with and trying to make some sense out of it. It has been lauded and deprecated. While some consider it to be the lighthouse, the GPS for an egalitarian society and for a liberal democratic nation, others have doubted its and claimed that it is nothing but a mixed breed consisting of adulterated genes, and as someone once described it, an English band on Indian soil. While the judiciary has sung its praises, the executive has questioned its quality and legitimacy. While the judiciary has expounded the silence of the Constitution, the executive at times tries to silence it altogether. In the last 76 years, we have wondered whether democracy and equality, justice and fraternity, liberty and dignity are mere myths of a constitutional past. Of course, today we have a wonderful panel of three senior advocates of Delhi, along with Mr. Sengupta, who is a critic, as well as the founder and the director of Vidhi. Despite his young age, Mr. Sengupta has written a very intriguing book called The Colonial Constitution. He not only delves into the history of the drafting of the Constitution, but most importantly, he makes a point, and the point is rather intriguing. The founding fathers missed the bus. According to him, instead of coming up with a creative constitution like the American one, the founding fathers merely took snippets from different constitutions and created nothing but a legal collage. According to Mr. Sengupta, perhaps we should debate and discuss whether we really need a new constitution or not. While Mr. Sengupta takes us into the past, Mr. Saurabh Kirpal takes us into the present, and he presents the constitution from another angle, namely, in his book, Who is Equal? The Equality Code of the Constitution, his argument is, equality is something very easy to preach, but extremely difficult to practice. According to him, one should not talk about ensuring equality, but talk about erasing inequality. We also have Mr. Ashwani Kumar, a former law minister and a senior advocate of the Supreme Court, who has written a brilliant book called Democracy in Retreat, Revisiting the Ends of Power. He highlights the constitutional transgressions and questions the decline of the political discourse. According to him, dignity and democracy are interrelated. Lastly, and certainly not the least, we have Nitya Ramakrishnan. Ms. Ramakrishnan is a leading human rights activist and a lawyer at the Supreme Court. To her credit, she has argued on behalf of the terrorist in the Parliament attack case. She has also argued the Harin Pandya's murder case. She has extensively commented about the friction, the fraction, and the fragmentation of the Constitution in the judicial arena. I would first like to begin with Mr. Sengupta, because he takes us into the drafting of the Constitution. Mr. Sengupta. For the first time in our history of 5,000 years, people were finally assured of the fundamental rights, the constitutional rights, the social and economic rights. Then what makes you name the Constitution as a colonial one? What is so colonial about the Constitution?
Thank you very much, Justice Chauhan. I think your question reminded me a little bit of when we used to watch cricket in the late 80s and 90s when I was growing up. And, inevitably all of us of that same generation have watched India. We thought that we would win this time and we would win a World Cup. And we would inevitably come back disappointed. And I had an uncle who always used to say, but at least we beat Zimbabwe. And we were all very happy that we had beaten Zimbabwe. And I think your question is a little bit like that, we at least have some fundamental rights, so let's be happy. Sure, we are very happy about the fact that we have fundamental rights in the Constitution, like we were very happy about the fact that we beat Zimbabwe. But the fact remains, and I think it's important to get into some of the detail of this, is that the fundamental rights that you talk about, let's take a classic example. Justice Chauhan was the Chief Justice of Uttarakhand, where actually a lot of people used to call him the Article 21 judge. Article 21 judge, because Article 21 is the heart and soul of our Constitution, our life and personal liberty, and he used to give a lot of people bail, a lot of particularly poor and vulnerable people bail, and so he was called the Article 21 judge. But even in that Article 21, which is life and personal liberty, if you read the constitutional text, it is constrained. Constrained by what? Constrained by the power of the state to preventively detain somebody. Preventive detention is essentially charging someone without any legal process being followed. It is that provision which was there in the Rowlatt Act, which Mahatma Gandhi had described as a black act. But when it came to the Constitution, our framers decided to play it safe. What was being protested against the Rowlatt Act the framers felt that it was necessary, not only in the Constitution, but in the fundamental rights chapter. So point number one is that the fundamental rights are there, but they are heavily restricted. And point number two, the reason why I still think it's colonial is not because of the fact that the fundamental rights are restricted, not just because of it, but because the institutions, and we see that even today, the institutions that we have are colonial institutions. If you look at the police service was essentially the Imperial Police Service, which became the Indian Police Service, same police officers, same services, same training. So there was no retraining that was done. If you look at the bureaucracy, it's the same bureaucracy. The entire institutions of governance remained the same. And one person had seen that this would be a problem. And that was Gandhiji. Because Gandhiji had said that unless you change those institutions, we will not have Hindustan, we will have Englistan. And I think today, we can see some of the remnants of that. When governors are trying to rule states. What were governors? They were stooges of the British Viceroy. But you see that this is what is happening even today, that the remnants of a colonial state still continue. The citizen is still below, and the state is towering above. That's why I call it colonial.
But when you say that we need a new constitution, what exactly do you envisage?
So actually, there's a clarification. I don't say that we need a new constitution. I say that we need an honest conversation about our constitution. As I write in my book, that there are several ideas in our constitution which are wonderful and need to be embraced. There are ideas around equality, which Saurabh has written about. There are ideas about secularism and religious harmony, which have to be front and center of any constitutional discourse in India. But equally, there are ideas about preventive detention. There are ideas about rights without duties. And particularly speaking, there are ideas about decentralization, which don't have a place. So if you ask me for particulars, I'll give you three, which I think should be part of any new constitutional conversation that we have. First is the idea of local self-government. I'm a Gandhian, and I believe that we need to think about local institutions of governance. We can't really have all the power in Delhi ruling over our lives, and maybe helped by the fact that I come from Calcutta, where we don't like Delhi very much. The second point is also that we need to ensure that we have a genuine conversation about fundamental rights. There is a reason today that despite Article 21 and despite fantastic judges like yourself, there is a reason today why the likes of Munawar Farooqi don't stand up and do their comedy acts and they are worried. There is a reason today as to why, after, irrespective of which government is in power, as in for every Umar Khalid, there was an Asim Tripathi. So the fact is that this is not a question, and I'm not here to play politics, this is not a question fundamentally about the BJP and the Congress. There may be differences in terms of shades, but I'm not a politician, I'm not going to get into that. But the point is that this is a question of the state and the citizen. And I think that the Constitution of India today, it has to be plainly said, has set up a state that towers above the citizen. The framers did it with all good intention. The intention was that we are now independent. So surely the state will work in the benefit of people. But it hasn't really turned out like that. So we need to think of a new compact between the citizen and the state so that we are, in cricketing terms, not only happy in beating Zimbabwe, but that we win the World Cup of Constitutions.
Mr. Saurabh, you talk about equality in 5 different areas, in employment, in education. And interestingly, you also talk about the corporate world in equality. And you also discuss about marriage. Now, while dealing with the personal laws, you're of the opinion that all the personal laws, and these are the laws that govern different communities depending on the religious community you belong to, and deal with marriage, inheritance, and adoption. You say the personal laws are heavily loaded against women. Then are you suggesting that the Uniform Civil Code is the answer?
Well, I think it's quite obvious that both in law as well as how law is practiced, because the two are different, there is this odds are stacked against women in our country. It's not just in marriage or in personal law, it's in employment in every sphere. Because we live in a patriarchal society. We live in an ancient society which has roots of patriarchy in our religious texts. And sadly, that is carried on into our current day existence. So yes, I think it's true that the laws are very heavily stacked against women. But I think to remedy that by way of a uniform civil code may not be the correct way at present. Because here, unlike Orgo, who has assiduously avoided party politics and discussion, I think we can't speak about the Constitution without talking about the milieu we live in and the current era we live in. It's very easy to frame a document which is gender neutral and like the Uniform Civil Code, and that would be fair to women. But the concern is that given the politics of today, if a Uniform Civil Code is to be drafted, it will inevitably be seen as anti-minority. Now, it may not be the case, but there is a tremendous trust deficit that exists in our country, and with good reason. I think we, in the last X number of years, have a lot to answer for ourselves as to why is it that the minorities in our country feel so vulnerable, and vulnerable they do feel. So we can't do that because whatever they do in the terms of the UCC will be seen as an assault on religious freedom, something that was discussed even 75 years ago when the Constitution was being framed, because at that point, the Hindu bill came, the Hindu law was reformed, but other laws were not, because there was this feeling that if we do too much, we'll spark communal fires. And that hasn't changed in the last 75 years. I'll give you one example of why we can't trust the Uniform Civil Code. I'll give you 2 examples. One is the triple talaq, right? The Supreme Court strikes down this noxious practice of a man saying talaq, 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 and the woman being divorced, right? The court has struck it down. Then the government goes one step further and says, all right, the Supreme Court has already said you can't have talaq after saying talaq thrice, but any man who says so will now be sent to jail for doing that act. The divorce won't happen in any case because the Supreme Court has said triple talaq has no place. But you will send someone to jail. In the meanwhile, that man's wife will starve, the children will starve, and this is a way, really, perceptually, attacking the Muslim community in the name of doing justice to women. Same thing with the UCC that has now come in Uttarakhand. I don't know if you've read it. If you have a live-in relationship now, you're supposed to procure some kind of a certificate from a temple priest or some religious authority that you are not within the prohibited degrees of relationship. We're bringing religion into a secular law. We can't allow that. So UCC will never be a secular law. It will always be the law stamped with the power of the majority, which in today's day we know what it is.
In your book, you have dealt with both the aspects of equality, equality as a jurisprudential principle, as well as its impact on different specific areas. Now, many people have this feeling that equality and reservation are self-contradictory stand. Do you see reservation as but a facet of equality, as the Honorable Supreme Court would tell us, or you think that they are indeed contradictory to each other?
Well, this is a topic that often makes me very unpopular in settings such as these because they're often frequented by most people from the upper caste. I'm pretty sure virtually there'll be no Dalits in this crowd, or there will be a very small number.
Judges at times have to be and act like the devil's advocate.
Yes, no, that's fair enough. And then one must speak what one believes, regardless of how an audience takes it. Something we don't do. There's not enough bravery around us these days, which is why we're in the mess we are in. So, about reservations and equality. Well, in one obvious way, reservations for people of certain caste, or indeed gender, are antithetical to the idea of equality. You are carving out some particular jobs and saying, all right, you will get it only because if you have a particular caste or a gender or whatever else. So in the face of it, to a beginner, I would say, it would seem that equality and reservations are opposed to each other. And in fact, this was the first judgment of the Supreme Court in 1950, which held basically the same thing. But the moment they said that, and faced with the reality of India, the Constitution was amended. The American First Amendment gave a whole host of rights to the Americans. Our First Amendment took away a large number of rights, including right to free speech, etc. But the reality is that when you talk about equality, asking two people who have tremendously different life experiences, education, and starting blocks in life to be treated equally is inherently unequal. Now, to take the millionaire son of an industrialist living in a city who has had massive amount of education and tutoring to get into one kind of a college, and a Dalit woman or a minority woman in a village, and saying, well, you both have the right to sit for this exam and we'll treat you equally, compounds that inequality and in fact is an insult to the person who have been trying to move up in life but is pushed down constantly by patriarchal structures, by societal structures, through the sheer act of having lived in an atmosphere ridden with discrimination, where that person starts believing that I am less than equal. So you need to only level the playing field. When you have reservations, it's not merely a case of cutting out a pie and giving it to one particular community. When you see how that pie is distributed, and you notice that there's virtually no one from the Dalits at the top of our ladder. You know, you have some presidents who have become, who are from the scheduled caste and tribes, because that's a largely ceremonial post and you can choose. But we have not had a single Dalit prime minister in our country. How is that the case? So the moment you have such tremendous inequality of outcome, you have then to remedy that and say, well, this is not reflective of the reality that India is. And how do we bring about change? How do we ensure that the most oppressed are treated fairly and equitably? That is one important way, is through reservations. So reservations in a way support equality to ensure some kind of equality of an outcome. So I don't think they're antithetical. On the periphery it may seem so. When you delve into the idea of what equality truly means, it isn't.
Thank you, Saurabh. Ms. Nitya Ramakrishnan, you have seen the functioning of the Indian judiciary at very close quarters. And the Indian judiciary has always prided itself as the archangel of the people's liberty and equality. But do you think it's a valid self-proclamation?
Sir, in my view, when it comes to personal liberty, the dominant trend of the judiciary has been to assert the norm but negate the consequence. You know, Justice Vivian Bose, one of the earliest judges of the Supreme Court, said that the Constitution, whatever its shortcomings, Arghya is right, Saurabh may be right, whatever its textual or other shortcomings, he considered it a brooding spirit to watch over the democratic aspirations of the freedom struggle. And that manner of approximating to the values which are nevertheless there in the Constitution and making them aspirations to be the endeavor to realize it as a polity is an enterprise to be chiefly driven by the judiciary, with the Supreme Court at the top. So whatever preventive detention is bad, the first time in 1950 it was challenged, the Supreme Court upheld it. It upheld it on the nature of the text that Arghya talked about, procedure established by law is any law passed by a valid body, namely the Parliament. But that's not the end of the story. The irony comes because over the next 75 years, the notion of fundamental rights was expanded exponentially. It was no longer that limited notion that anything passed by a valid parliament. Yet, when it came to testing serious inroads by the state into personal liberty, be it in the terror laws, which truncated due process, be it in the Armed Forces Special Powers Act, which gave the state power to shoot at sight, or even as late as now, when it comes to the Prevention of Money Laundering Act, which actually allows compelled self-incrimination and reverses the burden of proof. The Supreme Court has tolerated all this as perfectly compatible with the fundamental rights chapter of the Constitution. So it is an approximating to the values by our institutions that there is something that needs to be done. Arghya talked about Gandhiji. What did Gandhiji say? He said, real Swaraj will come, not by the acquisition of power by a few, but by the acquisition of the capacity to resist abuse of authority when it is done. Has our judiciary facilitated that? Or has it held personal liberty as something which is in thrall to the expediencies of state? And I would say that is the dominant trend. Having said that, I must also refer to the dissenting opinions, which have carted a dialectics of their own. The single dissenting opinion in the preventive detention case in 1950 later became conceptually the law. The dissent, lone dissent in the infamous habeas corpus case today is a beacon of light. So this approximation to the ideals of democratic aspirations in some way is kept alive. But I would say that it is not so much the dominant trend. And I would say that the same principle, secularism, also you assert that it's basic structure. But in many of your judgments, that protection to minorities is not there. So this is my view.
Ashwani Kumar, sir, in your book, you have a very interesting thesis. You say that majoritarianism is a dangerous thing when the fact is that democracy is said to be the will of the majority. Therefore, my first question to you, sir, is when there is a clash between the will of the majority and the need of the minority, which way does the Constitution of India actually tilt?
Well, this has been a perennial conflict. It is not of recent origin. Let us understand what we mean by constitutional democracy, because India is not only a majoritarian democracy, it is a constitutional democracy. And I think one of the finest expositions of this concept has come from Aaron Barak, who said, you take the fundamental values of society out of democracy, you challenge its very existence, and if you take out from your conception of constitutional democracy the will of the majority, you harm democracy. So somewhere you have to have a balance between the majority preferences on any policy decision, articulated and reflected in the will of Parliament or in the vote of Parliament, and the constitutional imperatives, which at all times as the prime law must prevail, because it is the fundamental values that inspire our Bill of Rights, namely the fundamental rights and the directive principles, which are the soul and the core of the Constitution. Therefore, without getting into this argument of, which is classically termed as counter-majoritarian argument, which I must say has two limbs to it. One, the judges are not accountable to the people, therefore judicial review is counter-majoritarian, one aspect. The second aspect is that the court is designed to be designed to be and structured to be a counter-majoritarian institution. It is there to tame the will of the transient majorities thrown up under special circumstances to the discipline of those values and those rights that inhere in us by way of our humanity, with which we are born and which we carry in our flesh from the date of our birth to the date of our death. So these are immutable. And therefore, any conception of constitutional democracy that takes the fundamental aspects of rights, namely liberty, equality, fraternity, and justice, well, from Gandhi to Ambedkar, from Plato to Rawls, Dawkins, all of them have built their notion of a just society around the sacrosanctity of the three pillars of our constitution, and indeed of any constitutional democracy: liberty, equality, fraternity, and dignity. I would like to take a minute to say that in my reading of the Indian Constitution, while it has all the elements engrafted in it, Indian Constitution, above all, is a dignitarian constitution. From point A to point Z, every single provision of the Indian Constitution aims at the advancement of human dignity, so that the court has now repeatedly said that dignity as a constitutional value is at the pinnacle in the hierarchy of our sacrosanct fundamental rights. And I think this is the finest exposition that has come from the court. My difficulty with the court as a counter-majoritarian institution, which it must be, and it should not become the echo chamber of the government of the day, is that it says all the right things, but does not live up to its mandate of enforcing them. In fact, if my memory doesn't fail me, Justice Chandrachud's very powerful dissenting judgment in the Romila Thapar case, he said lofty judgments by themselves do not secure the rights of individuals. In Bardakanta Mishra and in K. Nagaraj, the Supreme Court specifically said that the right to declare the law carries with it the obligation to enforce it. What is the point of saying dignity, equality, fraternity are sacrosanct, immutable, non-negotiable? And yet, every day under our nose, human dignity is being violated in one way or the other, whether it is sexual discrimination, or it is communalism, or it is parochialism, or violence of any side. Every moment, every day, when you pick up a paper, 90% of the Indian newspaper is filled with news that directly or indirectly tell us that human dignity is being violated in this country. And that, as a publicman, that as a lawyer, that as a citizen, that as somebody who's tried to read a little bit of Constitution, is most worried about. We are therefore, and I make bold to state, and that is the title of my book, we are a democracy in retreat, because democracy is not majoritarianism. It is not only popular sovereignty. It is the whole Bill of Rights that tames power to values, not to the transient majorities.
Ms. Ramakrishnan, you just mentioned secularism. How do you see the role of the Supreme Court in upholding or defending or diluting secularism? Because now there's a lot of debate. Many people claim the word secularism is an interpolation into the Constitution. Therefore, we can easily get rid of that word. Now, the first question, is it an essence of the Constitution, as the Supreme Court will have us believe that it's a basic structure? Or it is just a cosmetic change that we brought on and we can jolly well get rid of that cosmetic change?
Actually, whether or not that word was added, the entire Constitution is, in my view, testament to the values of secularism. Whether it does so adequately or not, there would be many opinions. And as I said, those are the aspirations. That is the manner in which we must interpret the Constitution. Now, they went to the extent of saying it's basic structure. But I'll just take the Babri judgment. You come to the conclusion that a temple was built there, that a mosque was built there in 1429. You come as a finding of fact that there is no evidence of a temple underneath. you also know there is material to say that up until 1857, and at that time there's a report that one community was inside, one community was outside. Yet you further come to the conclusion that the mosque was criminally destroyed. But the end result is that the criminal community benefits. I'm not. Then, while giving this judgment, you extol the Places of Worship Act like it's God's gift to humankind. And then, when a question arises as to whether there must be a fini to challenging other mosques, a question is raised in court. I agree. An observation of a judge may be to elicit many things. It is not a judgment. But nevertheless, it is the very basis of the judgment which you have yourself extolled as the ultimate in ensuring a certain spirit of the freedom movement, why 1947 onwards there should be no change in status. You raise the very question which has been dealt a completion, what do you call, a closure by that law, as a possible ground for litigation. It's something worrisome. I'm not saying whether a suit should go this way, that way. Cases go as per the facts. But there is something much more fundamental at stake. When you say whether, if this structure comes up here and this structure comes up here, then you will have to determine. That is exactly what has been said no to by this law which 5 of you have extolled and 1 of you just refers to. So these are worrying. These trends are worrying. That's what I'm saying. I'm not suggesting that a case should go this way or that way, nor am I saying that the Supreme Court's job to enter every thicket and say you do this or you do that. But when occasions arise and you can uphold values in consonance with the aspirations of the freedom movement, which I would like to believe were overall secular in nature, and then you take another option, then it is a matter for concern. That's all I would say.
Mr. Kirpal, in your book you deal with a very interesting topic of equality and the corporate world. How do you see inequality working in the corporate world? One would tend to think that corporate world, being a non-governmental arena, would be much more rational, much more objective, and therefore less unequal.
Well, I was rather enjoying the conversation about secularism, and so I'll keep the boring idea of corporate world and rather short. Or maybe I'll give a spin to it, if you don't mind, with your permission. I know you, often judges ask us tough questions in court, and one way to avoid answering a tough question is just by answering something completely different. So with that caveat, let me just say, rather than talking about equality in terms of the corporate world, often we don't talk about the equality which is most absent in our country is economic equality. We've talked about caste, religion, these other immutable characteristics because they're kind of easy to talk about and you can do things about it, not really affect my life. But every time around budget time comes a crusade of people saying, let's lower taxes. Why am I the only tax person paying tax in India? Why is there this government taking this money away from us? Well, obviously to counter the tremendous economic inequality in our country. We've succeeded in many things in our last 75 years of our history, to some greater or lesser extent. Economic inequality is a pernicious, deep problem that has still not been solved because it's not sexy enough to be discussed. The poor come and vote in hordes on the basis of promises which were never fulfilled or on being hoodwinked by every political party, not just the present, but the greatest respect, this hoodwinking has been happening for 75 years. So there is tremendous economic inequality in our country. And there's very little discussion about the immorality of living in a country where the poor are so completely destitute that there are famines and we don't talk about it. We become so immune to it that when we sit in our cars and drive around the city roads, you see a beggar come to you, you just block it out. Yet we will sit on this panel and discuss the inequality for the scheduled castes and religion, but economic inequality is absolutely ignored in our country, and that is possibly the most vital form of ensuring equality. You know, when a part of what an equality exercise is deciding how to cut up a pie. Now, if your pie is so small and everyone's poor, there will be greater fractiousness. There will be greater discord. But if you make the poorest of your country richer, expand the economic pie, a lot of these discussions we have about inequality will fade away. But I think really that's not someone is interested in, sadly.
Before I open the session to the audience, I'd like to ask a question to the audience. How many of you have read the preamble of the Constitution? Please raise your hands. Not too many. The majority is those who have never read the Constitution. Let me remind you what Justice Krishna once said. He said, if every Indian were to carry the preamble of the Constitution in his heart and soul, we will rarely ever go wrong as a nation. Therefore, my request to all of you is something that we have been discussing with the panelists. Kindly read the Constitution. Unless and until we understand the Constitution, which carries, and what the Honorable Supreme Court says, the Constitution tells us what is the constitutional morality, what is the constitutional philosophy. And therefore, my last question to Ms. Nitya, how do we protect and promote constitutional philosophy?
First, by not making a holy book of the Constitution. Second, by understanding that the Constitution is a site for debate without losing on what is integral to it. While what is integral to it may sometimes be a vexed question, oftentimes it is not. So the means of arriving at that conclusion must be equally constitutional, if you know what I mean.
With your permission, sir, if I could just add one thing.
Yes.
I think the point that Nitya makes is very valid, because there's something that has worried me, is that the Constitution is becoming like a holy book. And when it becomes like a holy book, it is something that is worshipped. It is kept at a pedestal, but is not engaged with. And that is why when we worship it, we may think it's great. But we saw this debate in Parliament which happened on the Constitution recently. Every party in the country, each of whom have done their fair share of demeaning the Constitution, was claiming the mantle of the Constitution themselves. Now, this is exactly the problem if you worship the document. That is why when the numbers came up, when you did this show of hands, I would just like to echo what Justice Chauhan said, that you can agree or disagree with the Constitution and its various fundamental facets. We have many disagreements here, but it is critical for each of us as citizens to engage with the Constitution. Because when we go out, and when I was doing some research for this book and I asked people what they thought of the Constitution, they said, wo to vakilo wali document hai. You know, but the Constitution is too important a document to be left to the lawyers and judges. The Constitution belongs to every citizen, and I hope that each of you will pick it up to try and understand what it says and what it means for each of us as citizens. Then only will we be secure as a democracy.
Since
Can
there
I
is
finally
a,
contrarian? Just 1 second. One very short comment. Contrary to the two of you, I believe the Constitution should be a holy book. Because at least there is a kind of a dhruv tara, something like a pole star, which is unchanging. In a place where everything is up for grabs, everything can be changed, majorities will come and alter. We need to have the inalienable ideals which are embodied in the Constitution, which are held in the hearts of every Indian citizen. And I agree with you. The Constitution does not belong to those 34 judges sitting in the Supreme Court who claim control over it. The Constitution belongs to every citizen of this country. It is meant for the people. It must be read by the people and appreciated by the people, and most importantly, safeguarded by the people. It's not for judges to do and lawyers to do their work and protect the Constitution by fighting cases once in a while. It's by people living their lives in an ethos which believes in secularism, which believes in equality, which believes in freedom and dignity to every Indian citizen. When you live that model life is when you will protect the Constitution.
Well, I
You were
just
trying
need
to say
make
something, sir.
I need to make a quick comment since the discussion went on some other aspects of it. We are in the 76th year of our republic. The fundamental question that we have to ask ourselves before we enter into a debate about who will protect the Constitution is, has our Constitution in action yielded democracy or politics that answers to the injunctions of our conscience? The answer is no. Has inequality been eliminated? The answer is no. Has exploitation been eliminated? The answer is no. Yes, we have made progress. Yes, we succeeded in lifting 400 million people above the poverty line in the last 2 or 3 decades. It is to the credit of all governments that played a part. The question is, the Constitution and the values of the Constitution are secure only to the extent to which we, the citizens, can assert those values through means available to us under the Constitution. More than the responsibility being cast upon the citizens to protect the Constitution, I think we cannot be oblivious of the fact that at the end of the day, in a democracy, the state and the 3 organs of the state that we created under the Constitution are duty bound to respect the discipline of the Constitution. It is wrong and unfair to expect an individual every time to knock at the door of the court or to knock at the door of the government of the day. So how do we do that? By sending to Parliament representatives who are conscious and sensitive to the aspirations of the people, to the sensitivities of the people. Democracy cannot be determined for us, certainly not by the Supreme Court of India, certainly not by the brethren in the black robes. In fact, in that very
Mr. Kumar, I think
just,
we should...
just 1 minute. One judgment, which was the judgment which struck down the challenge, or which refused to accept the challenge to the appointments procedure of the judges. One of the, Mr. Chalameshwar, in his dissenting judgment said, for how long will the people have faith in a court whose members have lost faith in the people? Remember that. That is the lasting point of democracy.
I would now like to request anyone who may want to ask a question. Yes, ma'am, on the front row. May I request all of you to be as precise as possible in your questions? Will somebody please give the young lady the mic? Thank you.
Good afternoon, everyone. I'm Dr. Anju Gehlot. And my question to Nitya Ramakrishnan ma'am. Ma'am, may I know your opinion on India is a positive secular state, and now it's a time to redefine the essential religious practices. May I know your opinion on it?
See, there was one view of secularism. I'll try and answer briefly. One view of secularism is that the state stays out. It does not promote religion. The other is that within a religious community, there must be some freedoms to that community which is not interfered with by the state. And that has to be developed on a kind of issue-to-issue basis. What contradicts public morality? Excommunication was held to be an essential religious practice which would affect the nature of the religion itself. However, there are some other practices which are in every religion which can be so repugnant to public morality that they cannot be considered either essential religious practices, or even if they are. So it is something, it gets redefined every time a challenge comes up. I don't know whether I've answered your question, but I hope I have.
Any other question? Yes, ma'am. The young lady in the... Yes, the lady behind you, ma'am. Yes. Yes, please.
Yes, myself Seema Sharma, retired principal of India International School, Sitapura. Though I have retired from the post of principal, but I really wonder why my students have not studied Constitution. So I don't know, I don't have any question for you, but I have a suggestion to make. If anybody can do something about including Constitution as an important part in the syllabus for students.
Thank you, ma'am, for your suggestion. Any other question? Yes, the man in the blue sitting with the lady in the yellow. Yes, sir. Please go ahead.
Very good afternoon. I am Dr. Madhvin Saxena, Professor of Mechanical Engineering. My question is very simple. What is the definition of equality in a 2024 and 25?
Definition of
Equality.
equality, Mr. Saurabh?
Well, I'm the leading expert of equality now.
Yes. Yes.
Kindly buy the book, it's on sale later. Well, you see, it's tough to figure out what equality is, but we all know what inequality feels like. So I think rather than defining equality, it's easier to say inequality is a way when, for no fault of yours, you are treated in a position that your dignity does not deserve. It's not about sameness. In fact, equality is about difference. The idea that everyone is treated as the same is not equality. That is the logic that was used in the hijab judgment by the by one judge, that everyone must wear school clothes and no hijab. That's equality. No, that is not equality. Equality is the right to be different and not to be held down because of it. The ability to live a fully free life with whatever life choices I make. The state will not come and say, this is better and that is worse. It's no job of the state. It's a job of the state to protect all of us.
Thank you very much.
Way back in the, yes, the young man in the blue jacket, yes. Yes, please.
Hello, good afternoon, everybody. My question is to Sir Ashwani, sir. Ashwani, sir, in the recent constitutional debate which was happening onto the Samvidhan in the context of the Samvidhan Divas, don't you see that there is a lot of photo op opportunities which are being garnered by politicians rather working on ground on the ethos of constitution? They are just for pictures queue. They are talking about liberty, equality, fraternity, justice. But when it comes to on ground, it is all flattered. It is cruel politics on ground. So how do you see this dissect in the politics?
Well, that's the unfortunate part of a democracy. Fundamental issues that concern the nation become the subject matter of photo ops. But having said that, there are people, and we can't sort of paint everyone with the same brush. There are people who are thoughtful people in public life, who think about the Constitution, who think about the values. There are many such people. But I must say that in recent years, those who are most responsible for infracting the Constitution speak most loudly about protecting the Constitution. This dichotomy is a dichotomy of our politics. You don't mean what you say, and you say what you don't mean. So therefore, the end result is, which is something that I discussed with Justice Chauhan, but it never came up, is the question, the centrality of the question of leadership in a democracy. You need elevating leadership. You need ennobling leadership. After all, post-independence India, people like Patel, Maulana, Jawaharlal Nehru, and so forth, Ambedkar, these were people who till now are quoted as the finest examples of India's representative democracy. After all, the same people, the same country. Why is it that our democracy is in distress? Why is it that our democracy is in retreat? Central to the issue is the question of leadership. And central to the question of leadership is perhaps, and I say so with some trepidation, the indifference of the people at large when they vote. They vote for reasons best known to them, but they don't necessarily elect the best candidates put forward by different parties.
Thank you, Mr. Kumar. As the last word, I just want to remind all of you that on May 29th, 1658, not too far from Jaipur, we had a decisive battle between two princes, Dara Shikoh and Aurangzeb. Many see it as a battle for the Mughal Empire, but in fact, if you look at it, it's a battle of ideologies, liberalism versus orthodoxy. Today we stand on the same forked road. The question is, do we learn to assimilate or do we preach extermination? Now the choice is entirely ours. Do we continue to be a liberal democracy or do we turn towards becoming an autocratic, elitist state? I'm sure you have all must have enjoyed the brilliance of the panelists. I'm really grateful to each one of my panelists for expounding on the Constitution, which I also believe should be held as the Holy Bible, the Gita, and the Quran for the modern India. Thank you. Thank you very much for being with us.